Good morning. Just wait for a few minutes just while everybody joins. I can still see that people are joining and signing on with us, so I'll just wait for a minute or two just while everybody gets into the webinar before we start. Good morning to those of you who are just joining us. We've got several hundred of you joining us, so it's just taking a while for you to all get into the webinar. So if you just bear with us a second whilst they still join, and then we'll get going. Okay, I think we'll start now, and the last few can join us as we get going. Well, good morning, everybody, and thank you for joining us today for this breakfast webinar in which we are going to be looking back at some of the key contract cases of 2022. My name is Rowan Turrall, and I'm a partner and head of dispute resolution at Boyes Turner, and I'm joined today by Sophie McDonnell, who is an associate chartered legal executive in my team. In putting together today's selection of cases, we've tried to select some decisions from which we can get some practical learning points with a view to helping you avoiding finding yourself in the same position as some of the parties in the cases. The topics that we're going to be covering today are formation of contract, intention to create legal relations, the construction and implication of contractual terms, interpreting a termination provision, two cases dealing with whether time was of the essence and whether a breach had been affirmed, and lastly, looking at interpretation of an exclusion of liability clause. I suspect we're going to be a little bit tight on time, so if you've got any questions or comments, please do feel free to use the Q&A box, and if we don't manage to get to them, we will follow up with you separately afterwards. So Sophie, over to you to kick us off with our first case.
Thank you, Rowan. I'm going to start today's session by looking at a case which deals with the formation of contracts. In L&T Aviation Limited and Airbus Helicopters UK Limited, the court needed to consider whether the parties had entered a contract for replacement of a helicopter gearbox. In 2013, the claimant, L&T, acquired a helicopter. In 2017, when the helicopter was nearly 30 years old, Airbus issued an alert service bulletin, or ASB, which required the planet gears in the main gearbox of the helicopter and that of many other helicopters of a similar type to be replaced. The ASB was accompanied by an airworthiness directive issued by the European Union Aviation Safety Agency, which made the implementation of the alert mandatory. The ASB referred to the Airbus paying for all direct consequences of the limitations induced by the ASB. At the time of the alert, the helicopter's main gearbox had less than 300 flight hours remaining before it would have needed a significant overhaul, which they estimated would be in 2019. The judgment sets out a detailed history of exchanges between the parties trying to get the gears replaced, including the submissions of purchase orders. In short, because of the ASB, there was a shortage of parts and the labour around the world, and helicopters used for the likes of the armed forces and the emergency services were prioritised. By the time it got to July 2018, the defendant discovered that the gearbox was an older version than had been previously assumed, which meant that the upgrade work to the gears could not be undertaken as originally planned. The gearbox therefore needed to be completely overhauled or replaced at a cost of at least €450,000, depending on which option L&T chose. This was compared to an estimated cost of only €4,000 for replacing the gears. L&T alleged in the proceedings that Airbus was contractually obliged to replace the gearbox at whatever cost, and they had been negligent by making promises that they would replace the gears. L&T relied upon correspondence spanning over several years to try to establish the contract had been agreed. L&T put forward 5 different alternative ways in which was alleged that a contract had been formed. What did the court decide? The judge concluded that no binding contract was entered into, and his decision included the following reasons. There was never a formal offer by either party to contract on a specified term of any final and unqualified acceptance to the terms of such a contract, i.e. no offer and no acceptance. Although the ASB referred to Airbus paying for all the direct consequences of the limitations introduced by the ASB, this was no more than an invitation to treat. It was nothing more than an indication that the Airbus group was prepared to bear the costs of the supply of the Planet Gears. The invitation was subject to the agreement of specific contract terms with the owner of the helicopter. Although a purchase order was submitted, this was a first step in the process of working out what was needed for each customer because of the ASB and was just merely to get the ball rolling. The purchase orders were not intended to propose or accept contractual terms. They contained little information and could not be construed as proposing clear terms for acceptance or acceptance of any terms already proposed. Other emails which L&T sought to rely on also did not amount to offers which were capable of acceptance. The obligation which L&T suggested was imposed on Airbus to implement the ASB at any cost and did not accord with commercial common sense. The agreement alleged by L&T was too uncertain and incomplete to amount to a binding contract. The fact the arrangement was not reduced to writing indicated to the judge that the parties did not intend themselves to be legally bound. The court therefore concluded in this case that the claimant's claim in contract must be dismissed. So what can we learn from this case in practice? The fact that L&T had to advance 5 different ways in which a contract could have been formed perhaps demonstrates the uphill struggle they faced. The case is an important reminder of the basics of forming a contract. Just because an abundance of correspondence has taken place, it will not necessarily show a clear intention to create legal relations, nor will it necessarily define the precise terms of a contract. A purchase order also won't automatically be treated as an offer or an acceptance. It is perhaps stating the obvious, but if you want to have a binding contract, make sure that you take the necessary steps to set out the terms in clear language and to ensure there is acceptance by the other party. Do not assume that a purchase order will always fulfill the function just because it sounds like it should be a contractual document. If it does not contain much information or does not propose or accept contractual terms, the court may find it's not sufficient. The next case also looks at the issue of whether a binding contract has been formed in the Pretoria Energy Company case. The court had to decide as a preliminary issue whether a signed document titled Heads of Terms of Proposed Agreement created a legally binding agreement. The claimant in this case, Pretoria Energy Company, operates an anaerobic digestion plants, and the defendant, Blankney Estates, is a farming business. In November 2013, following various drafts and iterations, the parties entered into an agreement recorded in a signed document headed with Heads of Terms of Proposed Agreement between Blankney and Pretoria, subject to full planning, appropriate consents and easements. The Heads of Terms envisage Blankney entered into a 25-year lease of the site, as well as other arrangements, including some demolition works and growing of maize as a fuel source. The parties also agreed a lockout agreement, exclusivity clause, whereby they were unable to negotiate with any other third party in relation to the site until the 31st of July 2014. It was agreed that this clause would be enforceable. Pretoria applied for planning permission, which was granted back in 2014. Pretoria then tried to engage with Blankney to progress the draft lease. Eventually, Blankney notified Pretoria in November 2014 that it had concluded arrangements for the site with a third party. Pretoria issued proceedings as they believed Blankney repudiated the contract in 2014, which resulted in them being liable for damages for loss of profit in the sum of 56 million and 416,000 in respect of reliance losses. By the time of the hearing, the issue in dispute amounted to the question of whether the section of the agreement headed lease was a binding agreement. The case serves as a useful reminder of the principles the court will apply when determining whether there is a binding contract. Sometimes, in the rush to get a deal done, these can be overlooked, so I'll just provide a quick refresher. The vaguer and more uncertain an agreement is, the less likely it is that the parties intended to be legally binding. The parties can agree to be bound contractually, even if there are still some terms to be agreed. It is necessary to look at the whole course of dealings between the parties, and this can include events after the making of the alleged contract to see if objectively they intended their dealings to be contractually binding. These events, however, would not be relevant to the question of how any contract made should be interpreted. The burden of demonstrating lack of intention to create legal relation lies on the party asserting it in a commercial case, and it's a heavy burden. If the parties intend to be contractually bound, the court will be reluctant to find an agreement is too vague to be enforced and may imply terms to fill gaps. The judge also noted that business people may record important agreements in a summary way. In this case, there were also relevant provisions under Section 2 of the Law of Property Miscellaneous Provisions Act 1989, dealing with the contracts for the disposition of land, although in the end the judge did not need to address them. Pretoria relied on the following in support of its position that there was a binding agreement. The absence of words subject to contract in circumstances where a solicitor had been involved in the negotiations about the heads of terms for Blankney and would be expected to know the importance of the phrase for negating contractual intention. The clarity with which the lease provisions were expressed in the heads of terms and the contrast of this with the language used in the other sections of the heads of terms, which was much more tentative and indicative of mere proposals. And the substantial time spent and expenditure incurred by Pretoria by making the planning application and growing maize pursuant to the licence, and the costs incurred by Blankney in demolishing the building and the site. In response, Blankney's case was as follows. There was never a binding contract for a lease contained within the heads of terms, and the only enforceable contract was the lockout provision in which the parties agreed not to enter any negotiations with the third parties until the 31st of July 2014. The time-limited lockout provision was incompatible with there being a legally binding agreement for a 25-year lease. The lockout provision clearly implied that after the 31st of July 2014, Blankney was free to enter negotiations with third parties, including for the grant of lease of the site. This would not be possible if Blankney had already agreed in binding terms to grant a lease of the site to Pretoria. Other relevant wording in the heads of terms were consistent with Blankney's case that only the lockout provision had contractual effect. The judge decided that the parties did not objectively intend to bind themselves to a contract by the heads of terms, other than in respect of the lockout provision. The following 4 points to the judge's mind were the most significant, indicating that the parties did not intend to create legal relations between them, except in relation to the lockout provision. The judge agreed with Blankney that the proposition that the parties had agreed a binding contract for the grant of a lease was incompatible with the lockout provision. Previous draft documents were considered, and the language in some of these documents, i.e. a reference to the parties adhering to all the terms, pricing and conditions of these heads and terms until the final agreement is accepted and signed, would have been a strong signal of being bound by the heads of term pending the agreement of final terms. However, this provision was deleted in the final version. The judge found that by accepting the deletion, the parties objectively agreed to a period of exclusivity for the negotiations rather than giving contractual force to the heads of terms. It was also agreed in the heads of terms that the lease would be contracted out of the Landlord and Tenant Act 1954. There are certain steps required under the Act before the tenant becomes contractually bound to enter the relevant tenancy, and these had not been completed. A major part of the agreement would be void if it was otherwise found to be effective as a contract. The judge did not consider that the parties had agreed all the terms of the lease, which were essential for the creation of legally binding relations. Whilst the language in the lease section of the document was more akin to agreement having been reached, this did not outweigh the other factors. There were still issues which needed to be addressed before the lease was granted, and in the judge's view, they did not intend to be bound until those issues had been resolved. For example, the parties did expressly recognise they needed to deal with the issue of what was to happen to the plant at the end of the 25-year period, but had not reached an agreement on that point. The judge found that that was an issue of commercial importance, and the parties did not intend to be legally bound until they had come up with an answer. In addition, on the lack of the phrase subject to contract on the document, the judge stated this was not conclusive, but it was an easy way in which parties may expressly show their agreement is not contractually binding. Here, when considering the terms of heads of terms and the parties' dealings, it was apparent they did not objectively intend to enter into a binding contract. The judge therefore found that there was no binding agreement except in relation to the lockout provision. So what can we take from this case to help us day to day? There are occasions when parties do not want to be bound by all terms whilst they are still negotiating a contract, but want some form of contract comfort that they are on the right track, whether that will be heads of terms or a letter of intent. It's critical to consider whether all or any of the document is intended to be legally binding. There may be some parts of the document, such as the exclusivity period in this case, for example, a confidentiality provision that needs to be binding to have any effect, but there may be other terms that need further consideration, and so you do not want them to be binding. As the judge indicated, the use of the phrase subject to contract and the heading heads of terms are not conclusive when determining whether a binding contract has been formed. However, they are an easy way to show that the parties don't intend to be bound. When determining if a contract has been formed, the court will consider all pre-contractual documentation, conduct of parties, and whether the basic principles of contract formation have been met. Here it was the lack of intention to create legal relations that was critical, but it's always important to remember the basics and consider whether there has been an offer, acceptance, consideration, intention to create legal relations, and certainty of terms. As ever, the use of clear language will go a long way to help us to avoid issues later down the line. This case is in connection with the well-loved character Paddington Bear. I don't want to set your excitement levels too low, but the judge opened her judgment by saying, anyone opening the judgment hoping to read an interesting, perhaps illustrated intellectual property case about the rights in Paddington Bear will be disappointed. This is instead a case about the proper contractual interpretation of an audit clause in a royalty distribution agreement entered in 2013 between Paddington and Company Limited and Pickstein Limited. We've included it today because it serves as a useful reminder of the correct approach to the construction and implication of contractual terms. Paddington and Company owed the IP rights in an arising out of Paddington Bear. Pickstein had an existing right to share in the net merchandising income from the worldwide exploitation of the Paddington Bear merchandising rights. The disputed clause was Clause 5, which is an audit clause that can be seen on the slide. During the term of this agreement, a third-party auditor may, upon prior written notice to Paddington, and not more than once per every 2-year period, inspect the agreements and any other business records of Paddington with respects to the relevant records or associated matters during normal working hours to verify Paddington's compliance with this agreement. Although 2 audits had already taken place in previous years, an issue arose in respect of a proposed audit in 2019, which resulted in the parties disagreeing about the interpretation of Clause 5 and the extent of the rights granted. Proceedings were issued on behalf of Pickstein, seeking specific performance and seeking declarations of the meaning of Clause 5. Paddington defended and issued a counterclaim for declarations of its own, which Pickstein also defended. The court considered there were a surprisingly large number of issues to come out of one simple audit clause. The reasoning for this was because the parties did not trust each other. As an aside, the barristers of the parties asked the judge to give as much guidance as possible as to what the clause entitled the parties to do and not to do, without leaving anything to the common sense of the parties to sort, as they believed they would not be able to do this. 10 issues were identified at the case management conference, including whether Paddington had to provide copies of all the documents to be inspected as part of the audit pursuant to clause 5, whether the inspection is limited to a physical on-site inspection at Paddington's office during normal working hours, and whether Paddington was entitled to redact documents seen by the third-party auditor. In order to have the rights and obligations that the parties were seeking, it was necessary for the judge to construe the clause and to consider whether any additional wording needed to be implied. The judge noted that the case of Arnold v. Britton in 2015 remains the leading authority on the issue of contractual construction. When interpreting a contract, a court should consider what a reasonable person would have considered the contract to mean, having all the background knowledge and language used in the contract. In this case, the judge placed particular emphasis on the following factors from the previous case law. The reliance on commercial common sense and surrounding circumstances should not be evoked, undervalued the importance of the language of the provision which is being construed. The purpose of interpreting a provision is to identify what the parties meant through their eyes of a reasonable reader. When considering the interpretation of terms, the less clear the words are or the worse they are drafted, the more opportunity there is for the court to properly depart from their natural meaning. Commercial common sense is not invoked retrospectively. If the terms have been interpreted to their natural language and they have worked out badly for one party, it is not a reason to depart from those terms. A court should be very slow to reject natural meaning of a provision as correct simply because it appears to be a very imprudent term for one of the parties. The purpose of interpretation is to identify what the parties have agreed and not what they should have agreed, and they should avoid rewriting it to assist an unwise party. The fifth point concerns the facts known to the parties. When interpreting contractual provisions, only facts or circumstances should be considered that existed at the time the contract was made, and it is therefore not right to consider facts or circumstances that only one party was aware of. Finally, in some cases, an event subsequently occurs which was not intended or contemplated by the parties. In these cases, if it was clear that the parties intended, the court will give effect to that intention. The court found that there was no dispute about the law regarding implications of terms in a contract. The leading authority for implication of terms is Marks and Spencer's plc, the BNP Paribas Securities in 2015. And the court also referred to the helpful summary of the relevant principles given by Lady Justice Carr in U Design Services Limited and Iliv Reality Pte Limited as to where a term can be applied into a contract. It must be necessary on an objective assessment of the terms of the contract to give businesses efficacy to the contract and based on the obviousness tests. Efficacy and obviousness are alternative tests. However, it will be rare for one but not the other to be satisfied. The business efficacy test is that without the term, the contract would lack commercial or practical coherence. The obviousness test is that it must be obvious, and to go without saying, what must be obvious is not just a term that should be implied, but what the term is. It must be capable of a clear expression. It must not contradict any express term of the contract. The question is to be assessed at the time the contract is made and not with the benefit of hindsight. The equity of a suggested implied term is an essential but not sufficient precondition for inclusion. The test is one of necessity, not of reasonableness. The law in respect of the implications of terms and construction of the contract was not in dispute, but the parties did not agree the appropriate application of those principles. In considering the terms, the court was satisfied on the balance of probabilities that Pickstein was legally represented at the time the RDA was concluded. Although the RDA was short, it contained some sophisticated and non-standard provisions, which strongly suggested that it had been professionally drafted and negotiated. The judge considered that the purpose of the clause was to allow Pickstein to check that Paddington was correctly accounting for the payments due to Pickstein at the time as protecting Paddington's information from Pickstein. As there were so many issues, I've set out I have not set out the judge's reasoning in relation to each one. However, in summary, the court found the following. Clause 5 did not entitle Pixteen to have copies of all the documents to be inspected as part of the audit. The clause clearly referred to a third-party auditor having copies of the documents. It was not obvious or necessary for Pixteen to have copies of the documents, and to imply such a term would undermine the careful choice of wording of the third-party auditor. Paddington was not obliged to send the documents to the third-party auditor in advance of the inspection. The court found that the auditor was required to attend a physical on-site inspection at Paddington's offices or any other premises under Paddington's control, although the auditor did not need to be supervised during the inspection of the documents. There was no blanket right for Pixteen to have copies of inspected documents from the auditor, but it was implicit that the auditor would be entitled to share the conclusion reached on the audit, the basis of that conclusion, and any underpayment found, what further sums are due, and the basis of the calculation. There was also to be implied term that the auditor could take copies relevant to the compilation of this report, because if asked at the time of the agreement whether this was necessary, the parties would have said, of course, that goes without saying. The court also found, except for the legally privileged documents, Paddington was not entitled to redact the documents that would be seen by Pixteen and their auditors. Some practical points. The audit clauses can be a very useful tool in many types of agreements to ensure compliance, particularly royalty agreements, such as this, or software licensing agreements. The decision shows just how many practical things the parties need to think about if they want to ensure that the audit clause provides them with the access to all the information they require, or conversely, that the clause adequately limits access. While the court was prepared to imply some of the terms sought by Pixteen, it was by no means prepared to imply all of them. I'll now pass you back to Rowan.
Thank you, Sophie. The next case that we're going to look at is the case of James Kemble and K-Line Europe, which deals with an interesting situation in which the court had to consider whether a notice of termination covered the factual circumstances which had actually arisen. At the relevant point in time, JK's business was road transport for shipping containers, and K-Line managed the import and export of shipping containers to and from the UK on behalf of a Japanese company in the same group called KKK. The parties entered into a service agreement for JK to provide road haulage services up to a defined maximum volume for a fixed period. K-Line also agreed to provide an agreed minimum volume of jobs to JK, the amounts of which were set out in the agreement over 3 periods. Due to a merger which involved KKK, K-Line was no longer going to be responsible for their container business in the UK, and as such, it was going to be unable to perform its obligation to provide the minimum volume of jobs to JK for the 3rd period of the agreement. The agreement set out how the minimum volume was to be calculated, and then it went on to state in clause 3.3, for each month that K-Line is not deemed to have complied with the provisions of clause 2.2, a K-Line shortfall month, JK's sole and exclusive remedy shall be to levy a surcharge in respect of that month. The agreement then set out a formula for how that surcharge was to be calculated. Once K-Line became aware of the change to its operations, there were several communications with JK, and in one letter from JK, they stated, given there are no provisions in the agreement entitling K-Line to discontinue using James Kemble, we are expecting K-Line to honour its legal obligations and pay us the revenues that would have reasonably been payable to us during 2018-19 had K-Line not transferred its business. They then indicated that the annual average revenue over the last 3 years had been a figure over £12 million and proposed that this sum be paid over the next 12 months upon the presentation of invoices. K-Line's response was as follows. To the extent that we are unable to offer you sufficient jobs to meet the monthly minimum, we intend to apply clause 3.3. This is the clause I referred to above, which set out a formula for calculating surcharge in the event the monthly minimum figure was not met. The judge noted that this response was important because it demonstrated that K-Line intended to comply with its contractual obligations, that K-Line considered the only remedy agreed between the parties for a shortfall in the minimum volume was that was set out in clause 3.3. However, JK decided it was going to terminate the contract, and it purported to invoke the termination procedure in clause 11.3a, which I've also set out on the slide. The notice that was served stated, K-Line is now in anticipatory repudiatory breach of the agreement. K-Line's breach comprises its unambiguous and repeated confirmation over a prolonged period of time that, save some short-lived and limited runoff business, it will not be complying with its with its clause 2 obligations in relation to period 3. There have been persistent and/or material and/or repudiatory breaches of clause 2. The notice went on to give 30 days to remedy, failing which JK said they would terminate and claim substantial damages. The judge noted that the alleged breaches were unexplained and unparticularised, and the letter failed to address K-Line's previous indication that it intended to comply with its obligations under clause 3.3. K-Line responded to say that it did not consider it was in persistent, material or repudiatory breach and was not aware that it was in breach at all. JK nonetheless purported to terminate once the 30-day period in its notice had expired. The notice relied on clause 11.3a, but this time it stated, you are in anticipatory repudiatory breach of the agreement and have failed to remedy this breach within 30 days. The judge highlighted the significance of this letter as follows. It asserted anticipatory repudiatory breach, but then purported to terminate pursuant to clause 11.3a, rather than for wrongful repudiation at common law. It didn't answer the points made in K-Line's previous correspondence, and it didn't make any reference to the allegation that there had been persistent and/or material and/or repudiatory breaches, and instead it referred solely to an entitlement to terminate under clause 11.3a for an alleged anticipatory repudiatory breach. JK issued proceedings to recover damages for the allegedly wrongful termination, initially valuing its claim at some £6.8 million. By the time the trial started, this figure had reduced to about £857,000, and by the time the trial finished, it was down to some £560,000 odd. K-Line argued that if it lost on liability, then the claim was worth somewhere between £148,200 and £195,140, depending on whether the contractual machinery applied or if damages were at large. I pause here just to note the importance of accurately assessing the value of your claim as early as possible. Sometimes this may be a complex exercise or require expert input. However, if one side thinks its claim is worth somewhere north of £6 million and the other side thinks that it's going to be less than £200,000, you can understand why a settlement may be hard to reach and why the parties have had to go all the way to trial. A difference between just under £200,000 and £560,000 is far more likely to be bridged in negotiations. And I don't know what the costs were here, but we had a 3-day trial in the commercial court, and both parties were represented by King's Counsel with a junior barrister on each side, so I expect that the costs were likely to have been very substantial. JK argued that clause 11.3a should be extended to include an anticipatory breach of contract. As they'd not expressly relied on wrongful repudiation at common law, JK had to bring itself within clause 11.3a or fail in its claim. As an aside, JK submitted that it would have been difficult or impractical to serve a notice which both purported to accept a repudiation at common law at the same time as relying on the contractual termination mechanism. The judge stated that the serving of such notices without prejudice to the effect of the other is a well-recognised and used technique. As the liability issues turned on the construction of the agreement and whether clause 11.3a could be construed in the way that JK argued, the judge started by summarising the principles applicable to the construction of a contract. Sophie has referred to some of these already, so I'm not going to read them out, but I have included them on the slides so that you can see another judge's summary of the relevant principles in the context of this case. And we will be providing a copy of the slides after the event, as well as a copy of this recording. So there's a continuation of the reminder of the principles of contractual interpretation. Having considered these principles, the judge applied them as follows. The agreement was a professionally drawn document entered into when both parties were legally represented. It was therefore to be interpreted principally by textual analysis. Neither party sought to rely on any contextual evidence other than what was set out in the agreement itself. The agreement therefore needed to be interpreted by reference to the natural and ordinary meaning of the provisions in the context of any other relevant provisions and bearing in mind the overall purpose of the provision and the agreement. The judge rejected the suggestion by JK that the provision should be construed using commercial common sense. Here, the parties had chosen how to allocate the risk of K-Line not supplying the minimum number of jobs. That might have appeared imprudent in hindsight, but that was not a reason for rejecting the natural meaning of the words used. The wording of the clause meant that K-Line had to be in breach on the date the notice was given under clause 11.3 and did not apply to prospective events. If the parties had wanted to mirror the common law position in relation to anticipatory breach and the contractual termination provisions, they could well have done so, but they had chosen not to do so. The remedy set out in clause 3.3 for failure of K-Line to meet the minimum requirements was agreed to be the sole and exclusive remedy for that failure. The contractual right to terminate was therefore not a remedy available for that particular breach. The termination provision could only be invoked if the breach had occurred at the point when the notice was served. The claimant was therefore not entitled to rely on anticipatory repudiatory breach under clause 11.3a. In any event, K-Line had made it clear that it intended to continue to comply with its obligations, in particular clause 3.3, which provided for the default payment in the event it couldn't supply the minimum number of jobs. Accordingly, the judge concluded that K-Line did not repudiate the agreement, nor had it threatened to repudiate it, and therefore JK's claim failed. So what can we learn from this case? When drafting termination provisions and exercising them, it's important to consider the interplay between common law and contractual rights. The options available may be different and the consequences following on from them may also differ. If you're serving a notice under contractual provision, make sure that the clause you're relying on in the contract reflects the alleged breach. If you can't fit your breach within one of the contractual clauses, you'll have to consider whether a common law termination is justifiable. If there is a two-stage process to trigger the contractual termination, then make sure the grounds relied on in those two stages are consistent. If you're choosing to allocate risk in the contract in a particular way, don't expect the court to come to your rescue if the remedy that you end up with appears to be one that it was imprudent to accept with hindsight. And don't forget the possible option of serving both a contractual and a common law termination notice, making it clear they're without prejudice to each other. This may potentially help you to minimise the risk of getting your termination wrong, or at least reduce the financial impact if you are found to have got it wrong later on down the line. The next case is the case of Pharmapack and HBS. The judge had to consider whether time was of the essence and whether the contract had been affirmed following a repudiatory breach. The dispute related to a contract for the sale and delivery of face masks at the beginning of the COVID pandemic. Pharmapack claimed there was an agreement finalised in an email dated the 10th of March 2020, pursuant to which HBS agreed to supply 5 million face masks at 30p per mask to be delivered in tranches of 500,000 per week for 10 weeks. Pharmapack was to pay £750,000 plus VAT for the initial £2.5 million masks, and then a further £750,000 plus VAT once the initial 2.5 million masks had been delivered. The email stated that the first 500,000 shipment would be available for inspection and collection on Monday the 16th of March, followed by 9 further weekly shipments. Pharmapack paid the first instalment and received the first batch of 500,000 masks on the 16th of March 2020. However, the batches due on the 23rd of March, the 30th of March, 6th of April and 13th of April were not sent. On the 23rd of April, HBS emailed Pharmapack offering to return the monies for the masks which had not been supplied to them, or to hold the money until the stock arrived. Pharmapack claimed that HBS was in repudiatory breach of contract. On the 3rd of June, Pharmapack accepted the repudiation and requested the return of the money, which amounted to £720,000. HBS failed to make repayment. On or about the 20th of June, the masks finally arrived with HBS, but Pharmapack refused to take delivery. Pharmapack issued proceedings to recover the repayment of the £720,000 overpayment, or for damages, arguing that it had been entitled to terminate the agreement because time was of the essence for delivery. In its defence, HBS argued that time was not of the essence. It claimed that the failure to supply the masks was due to restrictions imposed by the Indian government on the export of the masks, and that Pharmapack had said it was prepared to wait until the stock arrived. Its case was therefore either that it that there had been an oral variation of the contract, such that the delivery dates were extended, or Farmer Pack had waived any repudiatory breach, so it was no longer able to use that to treat the contracts being discharged by the failure to deliver on time. It further denied that its offer to return the money which it held on account amounted to an offer to release Farmer Pack from the contract. It counterclaimed for the payment of the balance of £750,000 plus VAT, an order that Farmer Pack takes delivery of the stock, as well as damages for the storage costs incurred during the intervening period. As I set out on the previous slide, the email which confirmed the oral agreement between the parties was brief and included the following wording. First 500,000 shipment will be available for inspection and collection Monday 16th March, followed by 9 further weekly shipments. On the question of whether it could be construed as containing a provision that time was of the essence, the judge took into account the following. The email did not explicitly state time was of the essence or that delivery time was a condition of the agreement. There is no presumption of law that stipulations as to the time of delivery are of the essence. They frequently are in mercantile contracts, but it remains a matter of construction. The agreement has to be construed as a whole and against the relevant background factual matrix. Farmer Pack was aware that HBS's ability to deliver on time was dependent on the circumstances over which it had less than complete control. Whilst the goods were not perishable, they were purchased against the background of the developing pandemic and an urgent need to sell them on. There were short and repeated delivery intervals with high demand and a volatile market. The judge therefore concluded that the clause could be construed so that time was of the essence as a matter of construction of the contract. He did note that if he had not found this as a matter of construction, he doubted then he would have implied such term as the contract would have been effective without it. The judge then looked at whether the email of the 23rd of April entitled Farmer Pack to terminate. Mr. Patel of HBS responded to queries from Farmer Pack requesting an update in the following terms. I can confirm we continue production and currently now hold circa 5 million masks in India awaiting shipment. We continue to produce if we feel that the requirement will continue. We can return your monies we hold on account to you or hold it until the stock arrives. Farmer Pack's case was that they understood this email to mean that they could either request the return of the money and the contract would come to an end, or they could wait until the stock arrived and the contract would continue. HBS argued that they were simply suggesting they would send the money back pending the completion of the contract. The judge agreed with HBS and found that this was not an offer to consensually terminate the contract, which was capable of acceptance by Farmer Pack. Even if Farmer Pack was entitled to terminate for breach, HBS argued that it waived its right to do so by affirming the contract. It relied on various communications between the parties in which Farmer Pack saw updates on progress with the deliveries over a period of time. When considering the question of affirmation, the judge said as follows. One has to bear in mind that a person entitled to make an election has a period of time to make up his mind what he is going to do. If he does nothing for too long, he may end up being treated as if he is affirmed. But if he maintains the contract in being for the moment while reserving his right to treat it as repudiated, if the repudiation is persisted in, he is not yet elected. Waiver is based on encouraging the purchaser to think that he will be given time indefinitely and will not be cut off without further notice. Mere standing by is not enough, at all events, unless it continues for an unreasonably long time. I've just spotted in the Q&A that there have been a couple of comments that people can no longer hear me. I haven't muted myself, so Dom and Sophie, are you able to tell me if you can still hear me?
Hi, Ro, I can hear you.
I can hear you as well, Rowan, yes.
Okay, I'm hoping therefore that it's only a couple of you that have got the problem. If anybody else is finding that somebody else's remark, they can still hear me. So I'm afraid it must be a couple of you that have technical issues rather than me, which is a relief for me. Thank you. I'll continue. So where were we? Various communications were relied on by HBS, but the judge concluded that these were requests for information upon the basis of which decision might be made, but had not yet been made about terminating the contract. As HBS had been expressing hopes that the masks would be released, the judge did not consider that Farmer Pack took too long to make a decision so as to have affirmed the contract. The judge found that Farmer Pack had validly terminated the contract for repudiatory breach and it was entitled to do so. It was therefore entitled to repayment of the sum of £720,000. I will leave it until I finished the next case, as they both cover very similar ground, and I don't want to give the game away, but in the next case, the outcome was different. So I've included both of these cases to show just how fact sensitive they can be and how easily they can go the other way. This time, rather than face masks, the subject matter of the dispute was an extremely rare Ferrari, only 40 of which were ever made, which, as you can imagine, gave it a fairly hefty price tag. By way of background, pursuant to a written contract made on the 24th of March 2021, Mr. Chen agreed to sell the car to DDC for €3.2 million. A deposit of €50,000 was paid on the 28th of March. DDC argued that it paid the balance on the 9th of April and has owned the car since then. Mr. Chen argued that he had not received the balance by the 13th of April, and so on that date, he terminated the contract. This was an application for summary judgment by DDC on 2 points raised in the pleadings. Firstly, was time for payment of the essence, and if it was not, then DDC argued that was conclusive of the case. However, if time was not of the essence, had Mr. Chen lost his right to terminate by waiver or affirmation. DD Classics was a classic car dealership in London, and it wanted to purchase the car from Mr. Chen on behalf of an Australian buyer. The car was in the possession of Ferrari. There was a long series of WhatsApp messages between Mr. Donovan, the MD of DD, and Mr. Chen, which culminated in a contract signed by the parties on 24th of March. I set out on screen some of the key contractual provisions, and I'll let you just have a quick scan through those rather than reading them out. The deposit was paid on the 25th of March, and Mr. Chen confirmed receipt on the 28th of March. On 29th and 30th of March, Mr. Chen chased for the payment of the balance. Mr. Donovan responded that he wouldn't pay the balance until Ferrari had confirmed it would release the car once Mr. Chen had received payment. Mr. Chen agreed and confirmed he had written to Ferrari asking for confirmation. The following day, Mr. Donovan said he was ready to pay the balance when he received the confirmation from Ferrari. The confirmation was received later that day, and Mr. Donovan then asked Mr. Chen to provide evidence of his purchase of the car, but he was not happy with what was provided. There was then a further exchange of messages, which concluded with the following from Mr. Chen, which I shall read out, not as if it's in text speak for fear of embarrassing myself. So in conclusion, you need to let me know if you will pay or not today or tomorrow. Very serious, otherwise we treat this deal as waived. The contract we signed is 5 business working days. Mr. Donovan then asked for further documentation about the maintenance and registration of the car. On 31st of March, he messaged, Mr. Chen messaged, which included, "Good night, my friend. If you want to keep this deal, then just deliver what you need to deliver today or tomorrow, otherwise we'll take this deal as off." After more messages, Mr. Chen wrote again the following day, "If you do want to close the deal, then please stick the agreement and pay the balance tomorrow and send me the wiring proof. The minute I saw that in my bank, I will immediately inform Ferrari to do the transfer." Mr. Chen said again later the same day, "All right, Daniel, make up your mind. Today is the final deadline, sir. If you don't do the remaining balance within today, I will officially call this deal off." Still, the money was not transferred, and Mr. Chen did not try to terminate the contract. I've skipped ahead a few days, but by the 7th of April, Mr. Donovan did transfer the money to Mr. Chen's account in Hong Kong, and he then repeatedly asked Mr. Chen over the next few days to confirm safe receipt. Mr. Chen said he had not received it, but on 12th of April, Mr. Donovan wrote to him saying he had confirmation that the payment had been credited to Mr. Chen's account on the 9th of April. After further chasing, Mr. Chen's response on the 13th of April was, "Dude, just pass me your account info and I will write the money back the next day I receive it, no more deals." DDC's case is that although the money was credited to the account on 9th of April, Mr. Chen failed to answer compliance questions from his bank, such that they refused to release the monies to him. Eventually, the money was released into his business account on the 25th of May, but by that time, DDC had obtained a freezing order, preventing Ferrari from releasing the car. Mr. Chen said that he would return the money and had kept it as a pragmatic step once the car had been impounded. The application before the court was for summary judgment, and DDC accepted that the issue of the date when the balance was received by Mr. Chen would have to be determined at trial and couldn't be dealt with by way of summary judgment. However, they instead relied on the fact that full payment of the price had been made, the price had not been returned, and the car had not been delivered. Mr. Chen defended the claim on the following grounds. On a true construction of the contract, time for payment was of the essence. He was entitled to withdraw from the contract if the price was not paid by the end of the 30th of March. The balance was not paid before the 31st of March, and so he was entitled to withdraw from the contract and did that on the 13th of April. He was ready, willing and able to return the price if DDC nominated an account to receive payment. The judge summarised the principles of contractual construction, which I won't repeat again here, having already referred to them. Mr. Chen sought to argue that various matters in the pre-contractual negotiations should be considered when construing the clause. The judge added that evidence of pre-contractual negotiations is not generally admissible to interpret a concluded written agreement, but evidence of pre-contractual negotiations is admissible to establish that a fact is known to the parties. However, none of the matters which Mr. Chen sought to rely on were found to be of any assistance to him. These included DDC telling Mr. Chen that funds were going to be available that week, and Mr. Chen having told DDC that he wanted a quick buyer. The argument essentially boiled down to clause 3.1, referring to payment being due immediately and the price having to be paid within 5 business days. The judge found this did not make time of the essence and took into account the fact that elsewhere in the contract, the parties had expressly used the expression time of the essence, but had not done so in this clause. There was nothing else, such as the circumstances of the contract or the nature of the goods, which meant that the time for payment had become a condition of the contract. The judge therefore found that Mr. Chen could not succeed in his defence that there had been a termination on account of acceptance of a repudiatory breach of condition in relation to timing of payment. The judge then went on to look at the position if he was wrong on the first issue and whether if Mr. Chen had had a right to terminate, he had lost it by waiver or affirmation. It was common ground between the parties that an innocent party will only be held to have affirmed the contract following a repudiatory breach if he acts in a manner which is consistent only with the contract continuing when he has knowledge of both A, the facts constituting the repudiatory breach, and B, of his own right to terminate in consequence of that breach. The only repudiatory breach relied on by Mr. Chen was the failure to make payment by the 1st of April at the latest. As can be seen from the communications I've highlighted, he didn't terminate at that point and instead was encouraging performance up to the 7th of April when the payment was sent, and then treated it as still afoot by seeking confirmation from his bank that he had received payment. It was not until the 13th of April that he actually purported to terminate. The judge was of the view that Mr. Chen knew what the contractual obligations were and what his rights were. Even if time was of the essence, the judge found that Mr. Chen would not have been entitled to terminate for repudiation. So then a different outcome here in this case to the Farmer Pack case. And as I said, it just goes to show how fact sensitive these cases can be and how careful parties must be when dealing with timing of performance and whether the failure to proceed on time amounts to a repudiatory breach. This is particularly the case if you're not immediately sure how you want to proceed and whether you want to accept a repudiatory breach or if you want to affirm the contract. As far as time of performance is concerned, in one case, the court was willing to find that time was of the essence, but in the other case, it was not. It goes without saying that if timing is important, then consider whether you need to include an express provision to make time of the essence. It may save you the cost of having to persuade a judge to construe your contract to that effect. If you suspect a repudiatory breach, then consider as quickly as possible how you want to proceed. How long a period of time you have to decide is going to depend on the circumstances of the case, but be careful of what steps you take while you're making your mind up. Lastly, don't forget there may well be situations where you do want to affirm rather than to terminate, but whichever route you do take, make sure that you act consistently. And now our last case, which is the case of CIS and IBM. Some of you who joined us for our presentation this time last year may recall us talking about the first instance decision. One of the comments that was posted in that chat was it was going to be interesting to see what the Court of Appeal had to say. Well, earlier this year, the Court of Appeal got its hands on the case, and so this is your opportunity to find out what happened if you've not heard about it before. In the opening paragraph of his judgment, Lord Justice Coulson remarked that at least £80 million turned on the construction of one clause in the contract between the parties. That clause was an exclusion clause which sought to exclude liability for, amongst other things, loss of profit, revenue and savings. The Court of Appeal had to decide whether to uphold the first instance decision that the clause excluded IBM's liability for wasted expenditure. By way of reminder of the background, IBM had contracted with Co-op for the implementation of a new IT system and the management of that system for 10 years. IBM subcontracted the supply of the software to a third party, and there were issues which resulted in IBM missing important milestones. IBM issued an invoice in respect of a later milestone, which CIS refused to pay as it said the payment was not due. IBM purported to exercise a right to terminate in respect of the non-payment. CIS argued that IBM did not have a right to terminate as the payment was not properly due, and IBM was therefore in repudiatory breach of contract, which it purported to accept. CIS brought a claim for damages, which included a claim for £128 million in respect of wasted expenditure from IBM's alleged wrongful termination. The court determined that IBM was not entitled to exercise its right to terminate and was therefore in breach of contract. For today's purposes, I'm going to focus solely on the question of whether CIS was entitled to succeed in its claim for wasted expenditure or whether it was excluded by the terms of the contract. IBM relied on the clause that I've set out on the screen with my highlighting. The important point being that neither party should be liable to the other for loss of profit, revenue or savings. IBM argued that although CIS's claim was framed as a wasted expenditure claim, on analysis it was a claim for loss of profit. Although calculated by reference to expenditure incurred, the actual loss was profit, revenue or saving that would have been earned by that expenditure if the contract had not been breached. CIS argued that the claim for wasted expenditure was not a loss of profit claim, and at first instance, Mrs. Justice O'Farrell agreed. Just looking quickly at her decision, she said the starting point was to look at the contractual benefit that had been lost as a result of IBM's repudiatory breach of contract. Here, the loss of bargain was a savings, revenue and profit that would have been achieved by having an IT system that was anticipated to increase CIS's business competitiveness and to produce substantial savings, increased revenues and increased profits. A claim for damages of this nature can either be framed as reliance lost, which is the expenditure incurred in reliance on the defence promise. Alternatively, it can be framed as expectation loss, which is the financial value of the expected contractual benefit, such as lost profits. CIS had advanced its claim as reliance loss, but Mrs. Justice O'Farrell said that did not change the characteristic of the losses for which compensation was sought. It was simply a different method of quantifying the loss of bargain. She therefore found that the claim was excluded whether it was quantified as lost profit, revenue and savings, or as wasted expenditure. She also commented on her judgment in the case of Royal Devon and Exeter NHS Foundation Trust, ATOS, in which a wasted costs claim was allowed by the court, even though there was a similar exclusion clause. She distinguished that case on the basis that the benefit lost in that case was not a financial gain, and CIS appealed the decision. In the Court of Appeal, Coulson highlighted 5 reasons why he considered that O'Farrell's construction of clause 23.3 was wrong. Firstly, he considered the judge had not looked at the natural and ordinary meanings of the words in the clause. He stated that claims for wasted expenditure were not excluded because those were words that were not simply there. The objective meaning of the words loss of profit, revenue or savings did not include wasted expenditure. The clause went into detail about what types of losses were excluded, but did not mention wasted expenditure, which the judge found to be telling. He looked at the proper approach to exclusion clauses and stressed that the more valuable the right being excluded, the clearer the language of an exclusion clause needs to be. He found that the parties could not be taken to have excluded wasted expenditure, which was an obvious and common type of damages when they had not made any reference to it in the clause. Loss of profits, revenues and savings can be distinguished from wasted expenditure. The former are difficult to be estimated in advance and difficult to prove. There is therefore a reason why those claims are routinely excluded. Wasted expenditure, on the other hand, is easy to ascertain. The claimant will have incurred expenditure for which they will have receipts, invoices, etc. Coulson found it made commercial sense to exclude uncertain types of loss, but not easily ascertainable loss. As he put it, the claims that would have compensated CIS from being better off as a result of the new IT system were excluded. The claims to compensate them for being worse off as a result of the non-provision of the IT system were not. Next, he considered what the loss of bargain was. IBM suggested that the sole loss of bargain was the savings, revenues and profits that would have been achieved from a successful implementation. He disagreed with this analysis, instead finding that the primary thing that was lost was the provision of a new improved IT system. The contract excluded positive interests, but did not exclude negative interests, namely the expenses incurred and the losses suffered in reliance on the contract. Lastly, he considered an argument which had found favour with the judge in this case, as well as in the previous case of Royal Devon and ATOS. That argument was that a claim for damage for repudiatory breach would usually be for savings, revenues, profits, had the contract been performed. wasted expenditure would be presumed to be recouped from that profit, revenue or savings, although that was a rebuttable presumption. As clause 23.3 excluded loss of profit, etc., it also excluded any claim for wasted expenditure. Coulson stated that the characterisation of wasted expenditure as a method of calculating loss of profits was an unjustified leap in reasoning. In the Royal Devon case, the judge found that a similar clause did not exclude liability because the claimant health authority had lost a non-pecuniary benefit. But Coulson disagreed that the position should be any different when a pecuniary benefit had been lost. The Court of Appeal therefore concluded that the judge had been wrong on the construction issue and had not followed the applicable principles. The appeal on this point was therefore allowed, and recovery of damages for wasted expenditure was not excluded by clause 23.3. So just very briefly finishing up with the last few learning points. Exclusion clauses like the one in this case are commonplace in many contracts, particularly those in relation to IT projects. How you deal with them when drafting will depend on which side of the fence you're on. As ever, the key to avoiding issues is clarity in drafting. If there is a particular head of loss that you want to exclude, then use specific wording to do so. As the judge said here, the parties had listed various types of loss that they wanted to exclude, but had not expressly mentioned wasted expenditure. And lastly, always remember, the more valuable the right being excluded, the clearer the language of any exclusion clause needs to be if you want to have the court uphold it. So that concludes our session. We hope that you found it useful, and I'm sorry for that mini technical non-glitch in the middle. Whilst every case turns on its own facts, hopefully we've given you some food for thought, some areas that can arise and help you to avoid some of the pitfalls that occurred for the parties here. You'll see that the slides include our contact details. So if you would like to get in touch with any questions as we've run out of time today, then please do feel free to call or to email us. We will be sending you a copy of the slides and a copy of the link to the recording after the event, should you wish to have another listen or to have a look through the slides. Thank you for joining us today. We would like to finish by wishing you a very happy, healthy and festive season. And we hope you'll join us at one of our events in 2023. Thank you very much.